Hello, everyone. First of all, I would like to welcome you to today's asset protection webinar. My name is Diana Dominguez, and today, as you see on the screen, we're going to talk about asset protection planning errors to avoid. Today's presentation is divided in three ways. First, I'm going to introduce why asset protection planning matters. Then we're going to talk about 4 of the most common planning errors we often see not only our clients do, but people in general do. And lastly, we're going to discuss some available resources that can help you get started with your asset protection plan. And if you already have an asset protection plan, just resources for you to educate yourself more about asset protection, have discussions with our attorneys about your current plan, and so forth. So why does asset protection planning matters? Asset protection planning, it's not just about protecting your assets. It's also about limiting personal liability. A proper asset protection plan allows you to avoid personal exposure to legal and financial threats. Let's say that you are a professional or you're a business owner. It's very important for you to have an asset protection plan that would allow you to avoid legal and financial threats, especially a plan that can ensure that your business and your personal assets are secured. Of course, an asset protection plan is very intimidating, but understanding the legal and financial strategies available to protect your savings, your property, your business from lawsuits and potential creditors, it's a very complex process. However, knowing what to look out for or what to avoid when thinking about asset protection gives you a head start in the process. The most popular planning error that we see most people do is waiting until it's too late to implement an asset protection plan. You know, it's the same way most people don't consider going to a medical checkup until they feel sick. Most people don't think about protecting their wealth until they find themselves on the verge of losing it. Say you hold off asset protection planning until you have a lawsuit or a liability. Most, I'm not saying all, but most legal financial strategies available might no longer be effective, or they have the possibility of getting invalidated in a court of law. Just to be clear, I'm not saying that there are no options for protecting your wealth if you have been sued, but depending on your circumstance, you may have fewer or you may have limited options available. Not only that, a last-minute plan or a crisis plan is usually more costly and more complex. So if there's anything that I advise you to take away from today's webinar, is this. When it comes to creating a strong asset protection plan, timing is the most powerful strategy available. A lot of our clients call and ask, when should they start their asset protection plan? When should they begin protecting their assets? And our answer is very simple. We tell them, plan to protect your wealth when you are free from potential claims or before you incur a liability. Ultimately, the goal with an asset protection plan is for you to become as judgment-proof as possible before you get a judgment against you. You should have the same commitment to protecting your wealth as you have in growing and building your wealth. At the end of the day, all the hard work that's put into getting a home, starting your business, or increasing your savings can all go to waste if you're not financially and legally shielding your assets. There are numerous strategies available to meet the goals of your asset protection plan. Most popular strategies are rooted in what we call a transfer-based asset protection. This involves the transfer of an asset so a creditor can't reach it. But unfortunately, there are many ways to go wrong with an asset-based protection strategy if you're not knowledgeable on the subject. A lot of people try to do their own asset protection on their own, not consult a professional, and this always leads to trouble, which leads to error number 2, fraudulent transfers. No asset protection plan is sound unless it can withstand a fraudulent transfer claim. Every state in the United States has a fraudulent transfer law. Sometimes states refer to them under the Uniform Fraudulent Conveyance Act or under the Uniform Fraudulent Transfer Act. These laws allow creditors to undo a transfer previously made by a debtor so that the creditor may claim or seize the asset in a judgment. Take, for example, if you are currently being sued and you decide to transfer an asset, let's say to your spouse or a family member or a friend, a week before the lawsuit begins. A creditor may convince, or worse, a creditor may prove to the court that the transfer was an attempt to defraud them. The court will then, or they have the option to, null and void such transfers, making your assets accessible for the creditor's reach. It goes beyond saying that it's so important that if you have a present liability, you discuss with an asset protection attorney to make sure that you're not engaging in a fraudulent conveyance or a fraudulent transfer, since it can destroy your protection completely. And to our earlier point on timing being the most powerful strategy available, whether an action can be considered as fraudulent depends on when it occurs. Every state has different statutes of limitations for fraudulent transfers. These statutes bar or block claims after a certain period passes after an alleged fraudulent transfer. This is confusing. Let's take Florida, for example. The general rule in Florida is 4 years. This means that a fraudulent transfer lawsuit must have been filed within 4 years of the date of the transfer. Of course, there are exceptions in the law, but if a creditor makes the argument that they've just discovered a potential fraudulent transfer during year 4 of the transfer, the court may grant them an extra year to prove that the transfer was in fact an attempt to hinder, to delay, or defraud them. It's important to remember that although you might think no one's gonna know about this if you hide it, if you don't tell anybody, in court, everything, and usually everything will be revealed. So you should have a plausible reason for every single transfer you make. The best course of action, we always tell our clients, of course, is to seek advice from an asset protection attorney who understands the complex natures of these laws to best predict whether the court will undo your transfers. When facing legal trouble or financial trouble, there are many people who look for ways to get assets out of their name, or at least out of their name until the threat they're facing disappears. However, retitling an asset to a friend, to a relative, or even your spouse can cost you way, way more than it will save you. It's important to understand that whoever holds title of an asset has the legal right to sell, to mortgage, or conceal the asset, not you, the person who's giving it away. This means that if a person you are trusting your assets with decides to cross you, divorce you, you call it, you have no right to recoup the asset because it's legally not yours. Moreover, if from an asset protection point of view, there is no protection in retitling an asset to another person because there's no guarantee that your friend, your relative, or your spouse will stay creditor free or free from any legal trouble. The same liability that you face is the same liability they face. Let's think, for example, say your friend or relative is married and you decide to transfer an asset to them, down the line, they get divorced or they get sued, they get into a car accident, someone slips and falls in their business. Now your assets are at risk of being lost. So taking all of that into consideration, retitling an asset to someone else, it's just not beneficial. And from a legal perspective, it's, it could become a fraudulent transfer. Because essentially, if you're retitling an asset to another person with the understanding that the asset will return to you once the legal trouble disappears, that's the definition of fraudulent transfers or fraudulent acts, because it is in fact an attempt to hinder, to delay, or defraud the creditor. The bottom line in this, in retitling your assets to someone else is that there's simply no benefit, and you should just not get involved in them in the first place. You're giving away your power, you're increasing the chances of losing your assets, and you're increasing the chances of committing a crime that will in turn be far more costly than keeping the asset in your own name. That's why, when people call us, when we have our clients, it's always so important to educate them on effective and, most importantly, legal ways to protect their assets in a way that allows them to remain in full control of them. If you're giving away your control, that's not a good asset protection plan. And even if you're discussing with different types of attorneys, they might not have a comprehensive view on how to create a plan that allows you to not have a liability, for you not to have to retitle things to another person's name, and of course, a plan that is cost effective for you. There is another way that people, of course, make the mistake of transferring an asset. Sometimes they do it by hiding it. Many people confuse secrecy or hiding an asset with asset protection, but that could not be further from the truth. If you are sued or you're facing any legal trouble, there is no such thing as secrecy. When you are asked to disclose your assets in court, you have two options. You either disclose them, you say everything you have with complete transparency, or you don't say what you have, and in turn, you commit perjury. So even if you think that, you hid your assets really well, you didn't tell anybody, that there's no shot anyone will find your hidden assets, just remember that there are very successful professionals in asset search firms that are dedicated to helping creditors and prospective litigants in relocating hidden assets. Doesn't matter how little you think that you've hidden away, they will find it. They've discovered millions of dollars in hidden assets, and they do it not just with wealthy clients, they do it with everybody. So there's simply no reason to expose yourself to even further legal trouble when there are legal strategies available to allow you to fully disclose your assets without facing the risk of losing them to creditors. At the Pressa Law Firm, it's not just, here's a plan for you. It's an educational experience. We tell you how to do this the legal way. We make sure that you understand all the types of strategies that we think are beneficial for you. And of course, if you do have, let's say you have a trust in place or any type of estate planning, we make sure that those things are implemented and that all your goals of protecting your assets are also the goals that can make sure that your future generations inherit those assets in a way that has asset protection. There are many resources that we offer our clients and potential clients, of course, here at the Pressa Law Firm. Essentially, to create a great plan, your planner needs to know exactly what you have and how to protect it. They need to have a full understanding of your financial and professional goals. And of course, they need to have the skill and the care to achieve your goals without compromising your protection. We have a couple of resources that allow you to have these conversations, as well as to educate you on the different ways that you can protect yourself against legal trouble. You can definitely submit your questions here in the chat or via email. You can schedule with the Pressa Law Firm a speaking engagement or keep registering, of course, for webinars like these. Every week we send out a newsletter with great tips and tools for you to strengthen your asset protection plan or to get started with one. We also provide our clients and potential clients, anyone with an interest, asset protection books. And of course, if you haven't gotten started, schedule your preliminary consultation with one of our attorneys. This will really get you started in your educational path. Make sure that all your goals are listened to and that you're able to then get started on implementing a plan that works for you. You can also visit, of course, our website. We have great resources there, educational tools that you should definitely check out. And with that, I feel like we've covered what I think are the most common errors when it comes to asset protection planning. We thank you for watching on behalf of the Pressa Law Firm. And of course, we invite you to connect with us on our social media platforms. We make our weekly posts available in all these platforms. On YouTube, we have many other webinars that are similar and go into more depth on certain aspects that we've discussed in today's presentation. We also do, estate planning, so check those things out. And we offer great articles and features that, just talk about how effective our attorneys here in the Pressa Law Firm are. So thank you so much. I see that there's a question here in the chat box. We'll definitely have an attorney answer that question for you. And I hope that everyone has a great day. Thanks so much for watching.